All right, anything we need to address before we bring the jury back? And we will, somehow I knew there would be.
Judge, I mentioned in chambers, one of the issues that I anticipate coming up that I need resolved before I put my first witness on is that, the first witness is going to be the child, the victim, who still has lasting scars on his wrist. And so I believe it would be legally appropriate.
And the rule has been requested. I just want to make sure everybody understands that.
Yes, Judge. I have two support members here that are non-testifying witnesses. I believe it would be legally appropriate for the child as a demonstrative aid as actual evidence to be received, to walk through the jurors for them to physically see his wrist. Now, I've got a few trials under my belt. I have kids of my own. I know that asking an 8-year-old child to walk through jurors and not talk to them and not expect anything to go wrong is a little bit chancy. And so what we've just done is that the prosecuting agent, Ms. Humphreys, has taken photos. I've asked for them to be printed off by my office so that I can provide them to Mr. Belmaris today. And those photos I intend to enter during Ms. Humphreys' testimony later on in the trial. If there's going to be a problem with that because of the late disclosure of evidence, which it's literally being given to them minutes after it was created, then I need to know that today, because this child needs to be able to show the jurors what lasting marks from the abuse he has on his body.
Mr. Belmars, you'll turn your microphone on there at the desk. You can stand at the desk.
The first issue is I don't know what these pictures are going to look like. I have not seen this child. The state has made every effort in this case to make sure that these children have never appeared in court. If you recall that standard practice has been changed to prevent the children from ever appearing in court. So I'm at a disadvantage of, I can't respond to whether I want these photos in or not based on what they're going to look like.
Where are the photographs right now?
They were taken moments ago here in the courthouse. I have asked one of my staff members to take it over to my office to be printed, but they were just taken, Judge.
Well, we have the charge, which is going to take probably 20 minutes for me to read, and your opening statements, reading of the indictment, opening statements, all of that will occur before the first witness.
Yes, Judge.
So make sure those photographs are back here, and before your first witness is called, we'll have a jury out hearing. I'll look at the photographs. Mr. Belmars can look at the photographs, and we will determine whether or not they are or are not admissible. But I would simply point out that the state is not prohibited from having the child victim to physically demonstrate scars to the jury. And a better way would be, of course, to do it in a photographic form. But I think Mr. Belmars has a right to see those photographs and to object to them if he chooses to. If that objection were sustained, it doesn't prohibit the state from having the child demonstrate to the jury those injuries. So my ruling is we'll reserve that until you produce the photographs. We will go ahead and bring the jury in and have them charged and let you make your opening statements, and then we'll deal with that issue before the first witness.
Thank you, Judge.
And we are ready for the jury. You can sit anywhere you want to now, so don't worry about having to stay in the same seat. All right, ladies and gentlemen, if you will each take your copy of the initial charge of the court that you have before you and follow along with me. Ladies and gentlemen of the jury, the defendant, Patricia D. Kelly, is charged in count 1 in the indictment with the crime of aggravated child abuse. In count 2, the defendant is charged with aggravated kidnapping. The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted, what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you go about reaching your decision. But now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime, and it is not evidence of anything. The defendant is charged in count 1 of the indictment with aggravated child abuse. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury that resulted in serious bodily injury to the child, and that the child was 8 years of age or less. The defendant is charged in count 2 in the indictment with aggravated kidnapping. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty, and that the defendant did so with the intent to inflict serious bodily injury on or terrorize the alleged victim, and that the alleged victim suffered bodily injury during the removal or confinement. The defendant has pled not guilty to the charge. She is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if he or she should so choose. Again, statements of the attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does put on proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you're to use in reaching your verdict. After you hear my instructions, I will select and excuse the alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in this case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against her. Thus, a defendant is not required to prove her innocence, to have her attorney make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must consider the evidence in each count separately. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify, and then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to a witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of the witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused, and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness, or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question, or the reason it could not be asked, please ask after court is adjourned, and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did the witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to the testimony. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experiences. There is no fixed set of rules to use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I decide on a particular rule of law. Do not draw any conclusion from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal question that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you are instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or a motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the term circumstantial evidence or direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of eyewitnesses. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence may prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during the deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with a pen and paper if you decide to take notes. There are several rules concerning your conduct during the trial and during recesses you should keep in mind. First, do not discuss the case among yourselves during the trial unless I instruct you on the law and you start deliberating at the end of the case. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Second, during the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway, on an elevator, or at some other point or some other location. If you do, perhaps the best standing rule is not to say anything. Third, do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. I do not know if there will be any media reports in the newspapers, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decisions solely on the evidence you hear in the courtroom. You may not communicate with anyone or provide any information, photographs, or video to anyone by any means about the case on your cell phone, through email, Android, iPhone, text messaging, video, FaceTime, Google Duo, Zoom, Facebook, Messenger, Skype, through any blog or website, through any internet chat room, or by way of any other social networking websites, including but not limited to MySpace, Facebook, Instagram, Snapchat, Twitter, LinkedIn, TikTok, Meetup, Pinterest, Reddit, and YouTube, especially including the live stream of this trial. In keeping with the state of Tennessee's open access to the court's public policy, the majority of court proceedings are live streamed via YouTube. You as a juror are not recorded on the video or shown on camera. You are not permitted to read, watch, or listen to those YouTube streams during the trial. You as jurors must base your decisions solely on the evidence you hear in the courtroom. I will remind you of your duty and your responsibility before all breaks in jury out hearings, and trust you will follow my instructions in keeping with the integrity of the case and court proceedings. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. For example, do not visit the scene of an incident, read any textbooks or articles concerning any issue in the case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing, and in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they will save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your court officers who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of the witness before taking a break. The usual times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full undivided attention to the case. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in the setting of the punishment. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictments in this case. General Bryson.
In the Circuit Court of Dickson County, Tennessee, at Charlotte, November term grand jury 2020. The grand jurors of Dickson County, Tennessee, duly impaneled, sworn, and upon their oaths do present that between May the 26th, 2020 and August the 4th, 2020, in Dickson County, Tennessee, and prior to the finding of this presentment, Patricia D. Kelly, then and there, did unlawfully and knowingly, other than by accidental means, treat R.C., a child under 8 years of age, in such a manner as to inflict injury, and the act of abuse resulted in serious bodily injury to R.C. in violation of Tennessee Code Annotated 39-15-402, and against the peace and dignity of the state of Tennessee. Count 2. And the grand jurors aforesaid, upon their oaths aforesaid, do further present and say that between May the 26th, 2020, and August the 4th, 2020, and prior to the finding of this presentment in the county and state aforesaid, the said Patricia D. Kelly, then and there, did unlawfully and knowingly remove or confine R.C. so as to substantially interfere with R.C.'s liberty and with the intent to inflict serious bodily injury on or to terrorize said R.C., or where R.C. suffers bodily injury in violation of Tennessee Code Annotated 39-13-304, all of which is against the peace and dignity of the state of Tennessee.
To that indictment, how does the defendant plead?
Not guilty, Your Honor.
Plea of not guilty. Ladies and gentlemen, the next step will be the opening statements of the attorneys. The state will again go first, so General Bryson, you may address the jury.
A summer with their grandmother was supposed to be fun. Patricia D. Kelly lives here in Dickson County, and her grandchildren came to stay with her between the dates listed in the indictment. There were 2 children. You will hear from the victim, Raynell Clinton Jr. His father is Raynell Clinton Sr. So the child Raynell goes by the name Junior. That's what he's used to being called. Raynell, who was about 3 and a half, a little bit younger than 4 at the time, along with his brother Jeremiah, who was 6 at the time. And towards the end of those dates, Raynell Clinton Sr. came a few days early as a surprise to pick up his kids. And he found that Junior had some injuries. He had some marks all the way around both wrists. He had some open sores, some wounds, and he began to ask the defendant about the injuries. The child did not immediately say or explain what had happened. And the father took the 2 children back home. Over the course of several days, he tried to manage with over-the-counter medication and bandages. But after several days, he took the child, he took Junior to his normal pediatrician. And the pediatrician's office recognized that these wounds were significant. They were not self-inflicted. They contacted law enforcement and DCS and sent the child to Vanderbilt for more in-depth treatment. Junior was kept 24 hours. The doctors at Vanderbilt determined that the wounds around his wrist were ligature marks, that what had been tied around his wrist had caused a degree of burns. And they will tell you that in their expert opinion that this was child abuse. Junior was able to have a forensic interview, and you'll get to hear from the forensic interviewer to explain what that is. But in a case where children have to give statements, giving a statement over and over can be difficult. For an adult, giving a statement over and over can be difficult. So a forensic interviewer whose job is to talk to kids about traumatic things that happened to them sat down with Junior
And you'll get to both hear and see that interview as Junior explains that Granny tied him up. You will see on the video how Junior, even though he is left-handed, will not use his left hand. He will draw with his right hand. Now, Junior, when he comes in to talk to you today, is an 8-year-old little boy. He has regained use of that left hand, but there was a while that he couldn't use it. And you will be able to see the lasting marks on this child of being tied up by his grandmother for a period of time. At the conclusion of the trial, you will have heard all of the facts necessary to reach your decision. You will be instructed by the judge regarding the law, which I spoke to you about in jury selection. And at the conclusion of the trial, you will have all of the information that you need to reach a just verdict.
Mr. Bell-Myers, you may address the jury.
Ladies and gentlemen, there are certain things in this case that are controverted. There are certain things in this case that aren't controverted. But the characterization of that this was a planned summer trip to grandmother's house would be the first thing. You're going to hear proof that it wasn't a planned summer trip to grandmother's house. You'll hear that, as had been the custom time and time again, Miss Kelly was willing to take the responsibility of taking care of these 2 children that were left in her care. Just like other times, she was willing to take in the family and provide them housing when they didn't have it. And you're going to hear examples over and over of how she's always stepped up to take care of these children. You're going to hear a story from a child who was 3 years old, almost 4 years old, that says, I broke a clock, I was taken to the basement and tied up. Now, you're also going to see proof that that clock was broken on July 16th of 2020. And you're going to get to see other things that happened on July 16th, 2020. You heard from witnesses that saw the children after July 16th, 2020. That aren't part of the family. Ordinary person that would certainly, if saw injuries to a child, would call the police, or at least ask what happened to him. You're going to see proof that Mr. Clinton did take Junior Clinton to the doctor, to his primary care physician, after trying to take him somewhere else, to a different doctor. It wasn't the normal doctor he went to, that he is established at, that he'd been taken to the entire time. But that he did take him to the primary care physician, and ultimately did end up in Vanderbilt Hospital. Now, the child was asked what happened. The child said, I don't know. That's what happened by providers in Clarksville. He was asked by providers at Vanderbilt. He was asked by DCS workers. He was asked by everyone. Couldn't explain what happened. But after meeting with the DCS worker, not Junior Clinton, but his brother made a disclosure to Dad about being tied up. But as I told you, or as we discussed in voir dire, you got to look at the details. The issue of rope burn was introduced by Dad in the beginning, long before any disclosures. We'll get to see what injuries did occur. We're going to hear from the experts about what may or may not have caused those injuries. But at the end of the day, it's going to be your decision, in your opinion, that matters about whether this was child abuse or whether it was not. That'd be one issue. And who did it? Because the medical experts can't tell you who did it. They can tell you what they saw. They can't tell you who did it. They can't tell you what happened in the 3 days from the time that Mr. Clinton had the children in his care after leaving Miss Kelly's care. Even if the proof says that it happened at her house, they can't tell you whether it was her or other people that lived in the home. Ladies and gentlemen, at the end of this case, as the judge told you, you're going to be asked to make a judgment to a moral certainty. And there's simply no way to do that in this case.
You know, Bryson, before we start the proof in the case, do we have the issue information that we need to deal with that issue? All right, ladies and gentlemen, as I explained to you, there are times when I have to have you step across the hallway to allow me to deal with a specific issue about certain evidence that may or may not be admissible. So I need you to step across the hallway there, and I will call you back as soon as I'm able to deal with that. You want to produce the pictures for me to look at as well, since I'm the one who has to rule on it? All right, Mr. Belmont, have you had an opportunity to look at those photographs?
I have, Your Honor.
Any argument you wish to make?
And I was trying to look quickly. Yes, my first argument, really probably my only argument, is that they're not relevant to the case. I believe, and that's what I was trying to look, the statutory requirement is obvious disfigurement to be serious bodily injury. Those photos clearly don't show obvious disfigurement. Second part of that is, if it's obvious disfigurement, we should be able to see it from the jury box to the witness stand, which is about 18 or 20 feet away from the closest and maybe 30 feet from the furthest juror. So that would be my objection, that they're not relevant.
Any response from the state?
I think the character of the evidence speaks for itself, and if it's not obvious disfigurement, then he should want the jurors to see them, so I don't really understand his objection.
In my opinion, the review of these photographs demonstrates that they show obvious scars or disfigurement of the wrists and hands or wrists of this young man, if in fact that testimony establishes that that disfigurement came as a result of the alleged acts of the defendant, then it would be highly relevant, and it would be evidence that would be demonstrable to the court, to the jury, and therefore any objection the defendant has is overruled and the state may utilize those photographs. I agree that the use of the photographs would be, in my opinion, more palatable than the child having to step across in front of 14 strangers and to demonstrate his injuries to those individuals standing before them. So we will allow the use of the photographs over the objection. All right, we're ready for the jury to be brought back. All right. Mr. Howell, if you'll let them know, we're going to be, in case they need bathroom breaks, go ahead and do that so we can bring them back in. I used it the other day. Yeah. Probably because of non-payment. I want to try it again. See. Well, let me show you what mine does. See all those red X's? All right. But yours is working. All right. State ready now? All right, let's bring the jury in. Y'all are messing me up when you go odd numbers on the rows because I have to try to take a head count to make sure I got all 14 of you. Ladies and gentlemen, we're now ready for the state's proof, so we're ready to call the first witness for the state.
State calls Raynell Clinton Jr.
Come right up here, young man. Can I ask you to scoot up to that microphone and speak into it, if you will, please?
Okay.
All right.
What is your name?
Raynell Clinton Jr.
Okay. Can you spell your first name?
Raynell.
How old are you?
8.
Raynell, what grade are you in?
2nd.
And what do people usually call you?
Raynell.
What else?
That's all.
They don't call you Junior?
No.
Hold on just a second. We have an objection.
Maybe I'm missing because I was.
He was
No.
not.
I'm
We were-
about to ask him a question.
Ladies and gentlemen, so that you understand, in young witnesses, we first establish whether or not the witness is competent to take an oath to testify. So these questions that are being asked by the state are to establish whether or not he understands the obligations that an oath to tell the truth will take. So,
Okay. Do people sometimes call you Junior?
Yeah, when I'm at home.
Okay. And is that because your dad has the same name as you?
Yeah.
Now, Raynell, what is the truth? Can you explain to me what it means to tell the truth?
It means when you tell something that's not lying.
Okay. So, do you have any pets?
Yeah.
What kind of pet do you have?
A dog.
So, if I were to tell the jury that you had a horse named Bluey that you like to ride to the moon, is that true?
No.
It's made up, right?
Yeah.
Okay. What does it mean to tell a lie?
When you tell something that's not true.
Okay. Now, what does it mean to promise?
When you make something that you cannot break.
Okay. So today, you understand that we can only say true things in
Yeah.
the court. Okay. And if I ask you, can you promise to tell the truth in here?
Yeah.
Now, if I ask you a question and you don't know the answer, what should you do?
Say I don't know.
If I ask you something that you don't remember, what should you do?
I'll remember.
Okay. Judge, do you have any additional questions on competency?
all right, young man, let me ask you a couple of questions. You go to school?
Yeah.
Okay. And do you or some of your friends sometimes get in trouble at school? I used
Kind
to.
of.
I used to get in trouble sometimes when I was a young man, but when you get in trouble at school, do bad things happen or good things happen?
Bad.
Okay. So if the teacher asks a question of one of the students at school about something that happened, let's say two guys get in a fight and the teacher asks what happened and somebody tells something that's not true, is that a good thing or a bad thing?
Bad.
And do they get punished because of that?
Yep.
Okay, so do you understand that telling the truth is a good thing, and if you say something that's not true, then that can be something that can lead to people getting punished, like in school. You understand that?
Yep.
Okay, so I'm going to ask you today, do you promise or affirm to me, do you promise me that you're going to tell me the truth and tell these folks on the jury the truth about any question that you're asked?
Yes.
All right, then I find he is capable of being competent to be a witness and will be allowed to testify.
So we have told your age and your grade. What do you want to be when you grow up?
I want to be a football player when I grow up.
Do you play football now?
Yeah.
What position do you play?
Lineman.
Where do you live?
Clarksville.
Okay, and I kind of asked you a trick question. Who do you live with?
My mom, my brothers, my sister, and my mom's friends, son, and my mom's friends, kids, and him.
Okay, so that's when you're with your mom some of the time. Are you with your dad some of the time too?
Yeah,
Who all's in dad's house?
my dad, my stepmom, and her kids, my brother, and that's all.
Okay. What's your brother's name?
Jeremiah,
How is he near your age?
he's 2 years older. He's 10.
In fact, you just had a birthday, is that right?
Yep.
Now, which house is the dog at?
My dad's.
Okay. Now, Jeremiah Junior, do you know why you're here today?
Yeah.
You're here to tell about something that happened to you.
Yeah.
Okay. Was it a good thing or a bad thing?
Bad.
What bad thing happened to you?
My grandma tied me up.
Where were you? Whose house were you at?
My grandma's.
And were you just visiting? Were you staying for a few days?
I was visiting because my dad had to do something.
Okay. So had you been there one day, more than one day, a lot of days?
It feels like a lot of days, or I think like a few.
Okay. Who all was there at the house while you were there?
My uncle, Jeremiah, and her.
Okay. So Jeremiah's your brother that's a few years older. Tell me about your uncle. Who's he?
So his name is Levi, and he was 14 at the time. Now he's like 20 something.
Okay. And did anyone else stay at the house other than you, Jeremiah, Levi, and Granny?
No,
Okay. You said Granny tied you up. Where were you in Granny's house when she tied you up?
the basement.
Okay. Tell me about the basement. What do you remember about it?
I remember seeing a pool table, and that's it.
Did it have carpet or did it have a concrete floor or something else?
Carpet.
Okay. Was anyone else in the basement when Granny tied you up?
No,
Did Levi come to the basement when Granny tied you up?
no,
Did Jeremiah come to the basement when Granny tied you up?
no.
When she tied you up, what part of your body was tied up?
My arms,
Okay. Both arms or only one?
both.
Okay. Do you remember how they were tied? And what I mean is, were they tied in front of you, behind you, to something else? What do you remember?
Behind.
Okay. And what did she use to tie you up?
A rope.
What do you remember about the rope?
It was kind of short, I think.
Okay.
I don't know.
Do you remember what color it was?
The same color as ropes.
Okay. So not purple.
No.
Okay. But you don't, I'm not sure what you mean by the same color as ropes.
So, like, do you know those normal ropes?
Let me ask this. Is there anything in this courtroom you see that is the same color or close to the color of the rope that tied you up?
This, but like a lighter?
The wood that you're pointing to?
Yeah.
Okay.
Like, it was kind of lighter than that.
So a light brown, is that right?
Mm-hmm.
Okay. Did she say anything while she was tying you up?
No.
Do you know why you were being tied up?
Because I think,
Objection, Your Honor, speculation. He said she didn't say anything. How could he know why she was doing something?
You know, Bryson, in response,
Judge, I think even an average person can look at a sequence of events and make a reasonable assumption.
I'm going to allow the question to be asked and answered by the witness if he has an answer. But ladies and gentlemen, it's being admitted to show what he understood about the situation as the alleged victim of a crime, rather than what it actually represents on the behalf of the defendant in the case. In other words, what he thought may have been happening may have been something entirely different from the defendant if in fact something like this occurred. So I'm going to allow the question over the defendant's objection solely to allow the state to ask him what he understood if he was tied up, why he was being tied up.
Okay, hold on. You're not in any trouble, okay? So why do you think you were tied up?
'Cause I broke a clock.
Tell me about that. What do you remember?
So, all I remember is me just sitting there in the basement getting be tied up.
Okay. So it's been several years since this happened. Do you remember all the details of what happened?
No.
But you remember being tied up. Did
Yeah.
anyone help Granny tie you up?
I don't think so, no.
Okay. Were you tied up one time or more than one time?
2.
Okay. Tell me what happened the first time. How did you get out of the rope?
So the first time I just wiggled out the rope, and then the second time it was just tighter.
The second time it was tighter? Okay. So when you wiggled out of the rope the first time, did you go upstairs or go somewhere? What did you do?
I was sitting there trying to take a sock off my head, but then I got tied up the second time.
Let's stop and talk about that. There was a sock on your head? Okay, how did the sock get on your head?
Oh, somebody put it on my head.
Did you put it on your head?
No.
Did Granny put it on your head?
Yeah. Guess so.
When you say you guess so, did Jeremiah put it on your head?
No.
Did Levi put it on your head?
I think so too.
You think Levi might have put it on your head?
Yeah.
Okay. When you say a sock, do you mean a sock like you would wear on your foot or something else?
A sock that you wear on your foot.
Okay. And when you say it was on your head, was it tied around your head or pulled over your head?
Pulled over my head.
How far down over your head was it pulled?
Like right here.
Okay. So you have gestured below your eyes, but above your nose. Okay, is that right?
Yeah.
Could you see with that sock on your head?
No.
How did you feel when you were tied up with a sock on your head?
Sad.
Do you like to be alone in the basement?
No.
Why not?
'Cause I was scared of monsters.
How did you get tied up the second time?
Tighter.
Let me ask this way. So you got out of the rope. What, if anything, happened between getting out of the rope the first time and getting tied up the second time?
I don't know.
Okay. Did you leave the basement at all between the two times you were tied up?
No.
Okay. Did anyone come down into the basement?
I don't remember.
Okay. Who tied you up the second time?
Grandma.
And you said she tied you tighter.
Yeah.
Do you know how you got out of the rope the second time?
No. I remember.
Do you remember when Dad came to get you?
Yeah.
What do you remember about when Dad came to get you?
So I was sitting down eating a popsicle with Jeremiah, and I saw a car, and then I saw my dad.
Did you know he was coming to get you that day?
No.
Do you know if that was the same day you were tied up or a different day?
A different day.
Do you know how many days between you being tied up and Dad coming?
No.
Do you use your left hand or your right hand to write and draw?
Left.
Your left. Can you use it okay now?
Yeah.
What about In the time after you were tied up, what was your left hand like?
This.
Okay, so you're holding up your hand and you've got all your fingers straight. Could you make a fist?
I think so, yeah. Like this.
Okay. Could you write
Yeah.
during the months afterwards? Or now?
Now.
Okay, what about during the time right after you were tied up? Could you use your left hand to write?
I don't know. I don't remember.
Okay. Do you remember if you had to go to the doctor about your hand?
Yeah.
Okay. Do you remember going to the hospital?
Yeah. No. I don't. If you don't.
I'm sorry, I didn't understand you.
No.
Okay. If people asked you back then what happened and how your hand got hurt and you didn't tell them, why do you think you didn't tell them?
Probably because I was scared to tell them.
What were you scared of?
Telling the truth.
Are you scared to tell the truth now?
No.
Okay. Did Miss Sarah come take some pictures of your hand today?
Yeah.
Okay. Do you still have marks on your hands from what happened to you?
Yeah.
Okay. I'm going to show you the pictures in just a second, but can you just generally point and show where the injuries are from the witness stand? Judge, I'm going to pass up to the witness, and I've provided this defense the same, a series of photographs that I'm going to ask Mr. Junior to look at. There are 6, 7, 8 photographs that I'm going to ask him to take a look at real quick. Do you see those photographs?
Yeah.
Are those your hands today?
Yeah.
Okay. Judge, I would move that in as collective exhibit 1.
Welcome as collective exhibit 1. You want those demonstrated to the jury?
I will publish at the end of his testimony.
Are you planning on putting it on the screen?
No, Judge, because they were just taken today. I don't have the electronic copies. Junior, did Dad ever tie you up?
No.
Did Levi ever tie you up?
No.
Did Jeremiah ever tie you up?
No.
The person who tied you up, you've described as Granny or Grandma. Do you know what her real legal name is? It's okay.
Yeah.
What is it?
My dad said it was Patricia, but I don't know.
Okay. Is she here in the courtroom today, the person who tied you up?
Yeah.
Can you point to her? Judge, if the record would reflect that the witness has identified the defendant,
All right, the record will so reflect.
we'll pass the witness. Okay. That means I'm going to sit down and Mr. Vilmaris is going to come up and ask you some questions, okay?
Okay.
Same rules apply to what he asks you.
Hello, Mr. Clinton.
Hello.
Do you mind if I call you Junior Clinton? Is that what you
Yeah,
go with?
sure.
Is that okay?
Yeah.
Now, Mr. Junior Clinton, you and I have never met before, correct?
Yep.
Never seen me before in your life.
Nope.
First time ever. So, I'm going to talk a little bit So how many years ago was it when you were staying with Miss Kelly?
Let me count. 4.
4 years ago?
Mhm.
Okay. And back then, you were 3, but now you're 8 because it's a different time of the year, right?
Yep.
Okay, gotcha. All right. Now, when Mrs. Bryson asked you first, she was asking you about where you lived. So, do you live part of the time with your mom and part of the time with your dad?
Yeah, we switch back every Friday.
Okay. And so, could you tell me again who all lives with your mom?
My mom, her friend, her friend's sibling, no, her friend's children, and my brothers and my sister.
Brothers and sister, or sisters, 1 or 2?
Sister.
Okay.
I have one.
And your brothers that live with you, what are their names?
Jeremiah and Sadiq.
And they're younger than you, those 2 are, right? I
No.
mean, excuse, Jeremiah's older,
Yeah.
but you have a younger brother and a younger sister, right?
Yep.
I got you. Okay. And at your dad's house, who all lives at your dad's house?
My dad and my stepmom and her children and my brother and me.
And when you say brother, is that Jeremiah?
Yeah, it's only Jeremiah.
And do you know how long have you been going back and forth between your mom's house and dad's house on Fridays?
8 years, I think.
So I want to back up to 2020 when you were at Miss Kelly's house. Do you remember being there?
Yeah,
Okay. And where did you sleep when you were at Miss Kelly's house?
I don't remember.
Okay. You don't remember where you slept?
No,
Okay. Did you sleep on the couch on the ottoman with Miss Kelly and Jeremiah?
I don't know.
Okay. And what kind of things did you do when you stayed at Miss Kelly's house back then?
I don't remember.
Okay. Do you remember flying kites while you were at Miss Kelly's house?
Yeah, one time.
Okay. Do you remember playing outside at Miss Kelly's house?
No,
You remember having a swing set at Miss Kelly's house?
no,
Remember jumping off a seesaw at Miss Kelly's house?
no.
Do you
I remember having a seesaw.
Okay, you said you remember having it, but you don't remember jumping off of it. That's okay. That's okay. Do you remember how many floors does Miss Kelly's house have?
3.
3 floors? Okay. And she has a basement. We all talked about that, right? And then we have the first floor. And what's on the first floor? Do you remember?
Mm-mm.
To have a living room, a kitchen, a dining room. And do you remember where Miss Kelly's bedroom was?
No,
No? Now, what kind of clock was it that got broken?
I don't remember.
Okay. Do you remember what color the clock was?
No,
Do you remember if it was a clock like that or was it different?
I don't remember.
And do you remember, and maybe or Miss Bryson asked you this, but do you remember, are you saying that you were tied up the same day that you broke the clock?
Yeah,
Okay. And Was the clock broke in the morning or in the afternoon or in the evening?
I don't remember.
Okay. Do you know where Miss Kelly was when the clock got broken?
No,
Do you know where Jeremiah was when the clock got broken?
no, I think he was playing with me.
Do you know where Levi was when the clock was broken?
No,
Okay. Do you remember who was asleep and who was awake when the clock was broken?
no,
Do you remember being on a video call with your father after the clock being broken?
no,
Do you remember being placed in timeout outside after the clock was broken?
no,
So, how many days are in a week?
7,
Okay. And do you know how many weeks or days there were from the day the clock was broken until your dad picks you up?
no,
Do you know, and you said, I think, strike that. Miss Bryson asked you, was it the same day? And you said it wasn't the same day, right?
no, it wasn't.
Okay. Okay. Now, do you know how many days it was from the day that your father picked you up until you went to seek medical attention?
No, no, I don't.
And do you know what your father was doing or what was going on and why he left you at Miss Kelly's house?
No,
Do you know where your mother might have been and why you didn't go to see her every other week while you were at Miss Kelly's house?
no,
Now, you saw a lot of doctors a few days after you left Miss Kelly's house, right?
I don't know.
Okay, okay. And that might have been my fault, the way I asked that question. Do you remember having a regular doctor that you would see every 6 months back around that time when you were 3 up until you were about 4.5?
No,
No? Do you remember going to a hospital in Clarksville?
no,
Do you remember going to a big hospital in Nashville?
no,
And so you wouldn't remember what you told the doctors at those hospitals if you don't remember going, would you?
mm-mm,
And you said when you were in the basement, the only people in the basement were you and Miss Kelly.
no.
No, is that wrong?
Yeah, it was only me.
Okay, I got you. And Levi wasn't there.
Mm-mm, no,
Levi wasn't there and throw a bottle behind you, did he?
no, he did throw a ball behind me, but he wasn't there.
Okay, so he wasn't in the basement, but he threw a ball behind you while he was in the basement. A ball or a bottle?
A bottle,
I'm sorry?
a bottle.
A bottle, like you drink out of. Okay. Now, do you remember before you left Miss Kelly's home, do you remember seeing a neighbor named Miss Mary Smathers? No? Do you remember seeing a lady named, give me 1 second, let me make sure I get her name right. Miss Nadra Patterson?
No,
Or do you remember seeing a neighbor named Bill Smathers?
no,
Okay. You don't remember seeing those folks? Do you remember what was your favorite thing to eat while you were at Miss Kelly's house?
so my favorite thing to eat, like, I would like to eat sandwiches, but I don't know if they had sandwiches. But I don't know what I'd like to eat.
But you don't remember if she had sandwiches when you were there?
No,
Okay. You remember playing video games when you were there?
no,
Do you remember when you left Miss Kelly's house, where your dad took you? Did y'all
No.
go to the park that day? Do you remember?
no,
No, you don't remember?
no. I don't remember.
Okay. And I'm sorry that I didn't do a good job of asking that. So, do you remember if he took you to Chuck E. Cheese that day?
No,
No, you don't remember? Okay. Now, do you remember speaking to a lady named Miss Post
no,
and talking about what you said had happened at Miss Kelly's house?
no. I don't remember that, but I saw a video.
Okay, so you don't remember that at all of making those statements to her?
Mm-mm.
Okay. Um, do you remember telling Miss Post that you were going to get some rats?
No,
You don't remember telling her that?
no,
And did you have a friend named Zayden?
no,
No? And do you remember telling Miss Post that Miss Kelly put socks on your feet when you were tied up?
no,
And her asking if it was one sock or two socks. Do you remember that?
no.
And do you remember telling Miss Post that when she asked what happened to your wrist, you said, I don't know, I ripped it off and I sewed it?
No,
You remember going up the steps at Miss Kelly's house?
yeah.
And how did that happen?
So I was at the steps for some reason, I don't know why. But then she came and then I think she put a box there and then I fell and did a backflip and hit my head.
So you remember that happening at her house?
Mm-hmm.
Okay. And was it the steps going from the first floor to the second floor? Or excuse me, from the main floor to upstairs?
Mm-mm.
Was it the steps going from the main floor to the basement?
I think it was the basement because there was like a door there, but I didn't know what it was. But I fell like, down like 3 stairs.
So it was the place where there are 3 stairs?
Yeah,
Okay. So it's the stairs that went from the main floor to the garage?
I guess so. Yeah.
And do you remember Miss Post asking you, did somebody hurt you? And you said no?
No.
You remember playing with Levi when you were there at Miss Kelly's house?
Sometimes I'll play with him on like I think like his like game, but I don't know.
What game did y'all play? Do you remember?
Like it was like I think it had to be an Xbox or a PS.
Do you remember what game it was or what kind of game it was?
It was like a Naruto game.
I'm sorry?
A Naruto game.
Okay, could you tell me what that is? I don't know what that is.
It's an anime.
Do you remember wrestling with Jeremiah?
No,
No?
no,
Do you remember knocking tiles off the wall while you and Jeremiah were wrestling?
no.
May I have just a moment, Your Honor?
You may. General Bryson, these, are you wanting to, before, when they're finished, are you wanting to demonstrate these to the jury? Let's wait till they're finished.
Do you remember riding four-wheelers around when you were at Miss Kelly's house?
No.
No further questions.
All right, Officer Howell. Sorry.
Jeremiah, I forgot to ask you something, but I'm so glad that Mr. Belmaris talked about it. So yesterday, did you watch a video that you gave of an interview? Okay. Did you realize that was the questions that Mr. Belmaris was asking about when he says Miss Post? That's the lady you were talking to. Did you realize that? No? Okay. When you watched that video, he shook his head no. So you guys say yes or no into the microphone for this lady because she can't see you shake your head. See, her back's to you. Okay. So you did not realize that's what Mr. Belmaris was asking you questions about, was that video.
Yeah, I don't.
So I'm going to show you the video and I'm going to walk it on up.
It's for the first letters of my name. So the R is for Raynell, the D is for Devon, and the C is for Clinton, and the J is for Junior.
Honor.
So did you watch all of this video yesterday?
Yes.
Okay. Now, the interview that you gave when you talked to that lady, did you tell the truth?
No, I don't think so. Cause it said she put socks on my feet. That's not what I remember.
Okay. So did you tell the truth on the rest of the video?
I guess so.
Let's think about that for a minute, because I don't want you to guess. You watched the video yesterday, and so you don't think she put socks on your feet.
No.
But think about everything else in the video. Did you lie about the socks, or you don't remember?
I didn't lie about the socks.
Okay. The video that you watched, did anybody tell you what to say?
No.
Okay. And did anybody ask you questions about stuff before the video? Is everything in that video that was asked?
No.
Okay.
I don't remember.
Judge, I would move this in as Exhibit 2 pursuant to the court's previous ruling, and I will play it with a later witness.
All right. Mark it as Exhibit 2. Anything further for this witness?
Your Honor, no, not at this time.
All right, subject to his recall as a witness, then he's excused for this point. He may step down. You can step down, son. They may call your next witness. All right, apparently I have, ladies and gentlemen, as I explained to you this morning, this job sometimes is like juggling balls. I've got another case that's come up that I've got to deal with an issue, so I'm gonna, this will be our afternoon break, but if you'll step across the hallway, let me deal with this case, and then we'll come back and continue our case. And we need to, whoever has the pictures, we need to make sure they stay in the courtroom. Just leave them there. Thank you. All right. We have Cordarius Godwin. Is this Mr. Spratt's case? Where is Mr. Spratt? Well, then why am I taking a recess to deal with something when the lawyer's not here? And we have that file up here. You have the, Leslie, do you have the Cordarius Godwin file? Good. Mr. Spratt, we're taking up your motion for reinstatement of bond, or actually it may have been your client's reinstatement of bond request. Right, then let's bring out Mr. Godwin. This is a motion to reinstate bond. Is your motion, Mr. Pratt, so you may proceed.
Address the court. If the court recalls, there was a hearing on February the 21st in this matter to revoke Mr. Godwin's bond. The court granted that. The sole proof at the hearing was a certified copy of an affidavit of complaint for a case in Lawrence County, which we objected to that. There was no testimony. Subsequently, and I believe we've attached that as an exhibit to, Mr. Godwin had filed a pro se motion, and I did file an amended. I hope the court's had time to review that. But as an exhibit A to that, it's the order dismissing that case. I don't think that's in dispute. What we would like the court to do is reinstate the bond, as that was the sole proof for the basis of the revocation. As the court's aware, this was set for trial in September, and the state late filed a range enhancement notice on Mr. Godwin, which triggered counsel to have to file a motion to continue. As the court knows, that's the only remedy, so that I could go over those enhancements with Mr. Godwin. So if the court needs to hear testimony, I don't think General Bryson's going to dispute the fact that that was dismissed. I think we're going to stipulate.
It was, according to your pleadings, dismissed because the motion to suppress was granted because of the unavailable officer. The officer that made the arrest, apparently, or made the charges, was no longer available.
Yes, sir.
That's what the order of that court says.
Yes, sir. And I believe we're going to stipulate to that. Yes. One moment, Your Honor. Sorry, Your Honor, the officer is deceased.
The what?
The officer in that case was deceased, which triggered counsel for Mr. Godwin to file the suppression motion.
He's deceased, is that what you?
He's deceased, which, Your Honor, goes back to our revocation hearing, and I understand the opinion the court relied on was my case, a case with Judge Lockhart Mash on objections to a Bergen's hearing without live testimony. And I believe what we've got here is bolsters that objection at these kind of hearings, because he's never been able to cross-examine anybody as to any of this proof, and he'll never be able to at this point. Mr. Godwin, I believe, is set for status with the court in December. I believe it's December 4th of this year. So there's no trial set. And, we renewed the objections that we made. I think the end result kind of justifies as to why we made those types of objections. And so if the court needs to hear proof, I mean, I would like to reserve rebuttal proof if the state wants to put up any. Mr. Godwin remained on bond throughout these charges, and it's been quite a while. And Mr. Godwin has stayed in contact with me constantly when he's out.
Well, the basis for the revocation was he was charged in Lawrence County General Sessions Court with driving on a suspended license, reckless endangerment, evading arrest. And under Tennessee Code Annotated 40-11-141 provides that a person released on bond who is charged with an offense while on bond, it may result in, or that the court has the right to then revoke that bond. So what I'm understanding is, and your argument is, that because those charges have now without question been dismissed that led to the revocation of his bond, you're asking for reinstatement of his bond.
Yes, sir.
All right. Now, if I reinstate his bond, are you saying that Booby's bonding company that made the $10,000 bond would somehow be magically required to be on the hook, so to speak, for it? Or
Well,
Or are you just asking to have the bond of $10,000 reinstated?
if, you know, I can't tie boobies bonding to anything, Your Honor, so I mean, in the
Especially
alternative.
since your firm represents most of the bonding companies.
Well, this court knows I never know what's going on with those, but
That is true.
if, you know, not to try to hold them to it, if they've been exonerated, you know, then the $10,000 bond would be an alternative argument, just to allow Mr. Godwin to be able to get out. And, I mean, these cases are, we believe that we're going to proceed to trial. General Bryson and I have had some discussions, productive discussions on them. But, you know, he's sitting here, and the basis is gone. And he has a new, and I can put on proof if I need to, Mr. Godwin has a newborn child. And we're just asking that if we can't reinstate it, then just reset it back at, because I believe that this case was the only case where the bond was revoked. It was the only case, it was the only docket number on the revocation motion. So I believe he's on bond on the other cases. So that's the argument. I don't, at the present time, I don't want to put on any proof if I don't have to, but I would like to reserve the right for rebuttal proof in the event Ms. Bryson wishes to put some on.
General Bryson?
I'm gonna try to keep all my paperwork straight, Judge. I am not going to call any physical witnesses. I do have some certified copies to give to the court. But I'm gonna sort of do the argument and everything all together as one. So Judge, first of all, for a procedural history of this case, these cases independently would have been grounds to revoke bond on the first case. The first case that he was charged with in in 2020 CR 192, he was on bond for that when he picked up the other charges.
Turn your microphone on.
I hate to object during statements, but
Go for it.
this was not the basis for any of the revocation. And
Is this going to be a lengthy hearing? It's going to be a lengthy hearing. We're going to take it up at 8 o'clock in the morning. We have a jury in this case that's waiting, and this case was not on the docket other than for this motion. If it's going to be an extended hearing, we're not going to keep the jury in this case waiting. We can hear this at 8 o'clock tomorrow morning.
Judge, I need probably 10 to 15 minutes to walk through everything that I need to put before the court.
Well, they've already been 10 minutes into this, so we'll resume this tomorrow morning at 8 o'clock.
Yes, Judge.
We'll stand at recess for at least another 10 minutes before we resume the trial. bring the jury back in the Kelly case then? How late do you need to go? Pardon? Well, I mean, well, do you want to call your pediatrician out of order, or do you want to put on your victim's father? In answer to your question, it's not a question of how late I want to stay, but how late I'm going to require the jury to stay and give it your attention, give it their attention. The issues that have resulted in this case dragging on have not been the jury's fault, for one thing, but call your first witness and we'll go from there. All right, bring in the jury. All right, General Bryson, you may call your next witness. Glenn, if you'll come around here to the witness stand, please.
Are you Raynell Clinton Sr.?
Yes, I am.
Okay. And you may have to pull that up just a little bit so that, the whole thing will bend like this, just so that you don't have to bend down to talk into it. So let's try that again. Are you Raynell Clinton Sr.?
I am.
Okay. And your son has already spelled Raynell for the court reporter, so I won't put you through that. Who is Patricia Kelly to you?
My mother.
And do you have siblings?
I do.
What siblings do you have?
I have Marvin Clinton Jr. and Levi Kelly. And I have another one, Trayvon Clinton, with my dad's side. And I can't remember the daughter name, my little sister, but
And you have Raynell Clinton Jr., and you have Jeremiah, right, for
correct.
sons?
Correct.
Who is their mother?
Angelica Johnson.
Do you guys share custody of the two of them?
We do.
Has that always been non-bumpy?
It's been bumpy at first. It was really bumpy.
Are you saying non-bumpy?
I did. I couldn't come up with a better word at the moment, so we went with non-bumpy.
Has the relationship been contentious in the past? Difficult, or has it been on
It was
smooth
very
sailing?
difficult. It was very difficult, but now it's very smooth sailing.
Right.
So not bumpy anymore.
It's not bumpy anymore.
Was there a period of time in 2020 that you asked your mother to keep the two boys?
I did.
About how long was that time period?
I believe the class I had to take was 10-month class. I think I had to go 2 or 3 times a week or something like that.
Did you say a 10-month class?
10 week, I'm sorry.
Okay. And were they in school during that time, or was it during the summer?
It was during the summer, but I don't think they was the age of school yet.
Okay. Who was living at your mom's house during the time that the boys stayed with her?
From my understanding, it was her and Levi Kelly. And at the time, my boy stayed with them for a little bit.
Okay, who's Levi?
My little brother.
How old was he at the time?
I don't know, maybe 16 or something like that, I think.
Okay. He was a teenager.
Yeah, he was growing up. He was like a kid turning a teenager, so maybe somewhere around there.
Okay. Did you talk to the boys while you were gone?
A little bit here and there.
Okay. Did you like FaceTime video call with the boys while you were gone?
Nah, we didn't do FaceTime then, but I talked to him over the phone.
Okay. Did you know your mom's neighbors?
Yeah, I think I knew one of them, 2 of them. I don't remember their names, but elder couple.
The day that you came to pick up the boys, was it the day you were supposed to come, or was it early?
No, it was early.
Okay. Did anyone know you were coming?
No.
So it was a surprise.
Yeah.
Okay. Tell me about coming to pick up your boys.
Well, I had got done with my class early, and me and the girl who I was talking to at the time, we was like, well, let's go get the boys and, celebrate. So that's what we did. We went to go pick them up, and I found Junior, like, wrist was messed up and stuff.
What do you mean his wrist was messed up?
Well, she said it was cuts. It looked like rope burn to me.
Okay. Who is she?
My mother.
Okay, so she said to you that the injuries were cuts.
Yes, from her China glass clock, the old school China glass clock. So he broke it or something like that. And at the time, I don't think he's always been a big boy, but he was what, 3 years old maybe? I don't think he could have did that.
Okay. So you did ask her, where did these injuries come from?
Yeah. I asked her what happened.
How many times do you think you asked her what happened?
Maybe I asked her what happened when she told me over the phone that he fell in his head or something, or something about the China clock. She told me about it. I'm like, well, you take him to the hospital? He cut himself, and the answer was no. I'm like, okay, that's weird. And if it's not that serious, you calling me like it's serious. Like, why are you calling me? If it's serious enough for you to call me like this, why are you not taking him to the hospital?
Okay,
Makes
back
sense.
up and explain. Because you said if it's serious enough for you to call me. So
Right.
did she call you to tell you that your child was injured?
Yes, and I was like, okay, well, what's wrong? Well, this happened, is it bad? And she's telling me, I'm like, well, are you taking him to the hospital? And she said no, so I didn't think it was that serious.
Okay, so let's slow down and explain that. So when did she call you to tell you that your child was hurt?
She called me sometime, I don't remember exactly, but sometime I was doing the class one of the days. She called me and told me that he hit his head or he did this to the clock. I'm like, okay, maybe it was like a couple of weeks before I went out there, maybe, roughly.
Okay. And you didn't come home to check on him?
What do you mean? They wasn't with me.
You didn't leave your class to come back, so you,
I didn't have a car.
okay. So she calls a few weeks before your class is done and tells you that Junior has been hurt and it's something to do with a clock.
Right, but I didn't know the magnitude of it.
Okay. Were you able to see Junior? You said you weren't FaceTiming during that time.
I didn't see him. I don't think I seen him.
Right. Was she able to send you pictures?
No, she didn't send me no pictures. Not that I recall.
Did she tell you about any other injuries during the time that he was there?
Only thing I think I recall is the head and on hands.
So that was before you saw him. After
Right.
you saw him, how many times do you think you asked her what happened to Junior?
I don't know. I couldn't even tell you honestly.
What was your reaction to seeing these injuries on
I
your
was
child?
kind of freaky. Now I was like, that's not a cut. It's not consistent with a cut. It looked like rope burn. That was my thing.
Did you take him to the hospital that day?
No,
Okay, what did you do
Well,
that day?
initially when I came in, she had gauze on him and she said it needed to be changed or something like that. So she took it off and blood just gushed off his hand. I'm like, that's not right. So we left and I tried to soap and water, Neosporin, ibuprofen, see if the swelling goes down and, nurse him back to health. It did nothing and he was just not himself. So I took him to my pediatrician.
So let's back up and go through the days slowly.
Okay.
When you guys left, did you do anything fun that day?
We didn't do anything fun when we left. We tried to do the park like the next day or something, but he was not himself.
What do you mean?
We tried to take him to the park.
Yes, but what do you mean by he wasn't himself?
Well, Junior, he's I don't know, he's like the life of the party. He's outgoing. I don't know, he's just really fun to be around. He's enjoyable. I don't know.
Okay,
He's
and what
really-
was he like that day?
He was really shelled and like not himself. I don't know, just he wasn't laughing, he wasn't playful, he wasn't nothing. He was just shelled and like
Was he able to climb things at the park, like a slide or a
I
playground?
don't think he attempted to.
So during the days between when you picked him up and when you took him to the pediatrician's office, how many days do you think it was before you took him to the pediatrician?
Maybe a day or two.
And did you do anything to take care of the wounds during that time?
Yeah.
What did you do?
I had gauze, I had ointment, I had ibuprofen for the pain and swelling, and also had peroxide. I was cleaning the cuts and everything, but it did nothing.
When you took him to the pediatrician,
Yes.
now let's just lay this out. Every parent is afraid of DCS being called.
Right.
Were you afraid of that?
Oh yeah.
Did you talk to the nurses about whether or not they would call DCS?
No. I don't think I had a conversation with them about that.
Okay.
I
Did you-
mean, that wasn't on my mind at the moment because I knew I didn't do whatever.
Did
was
you have
done.
any problem with DCS or law enforcement getting involved with what happened to your son?
No. I mean, I was willing and ready to go because I knew what it was.
And so from the pediatrician's office, where did they send you?
To Vanderbilt burn unit.
Okay. And now, how long were you there at Vanderbilt?
Oh, I think a day to maybe 1 or 3 days or so, something roughly.
And during the time that you were in the hospital, what was Junior like?
He was getting better, but I don't know, he really up under me, like sad and
Up under you.
Yeah.
That's a good parenting phrase. What do you mean by that?
we was cuddling on the bed, I was telling him it's okay, rub him down and being there for him and stuff.
After you were released from the hospital, did DCS come out to your home?
Yes.
Okay. I'm going to show you some photographs and see if you recognize those as being from that visit. Judge, there are 5 photographs. The same have previously been showed to defense counsel.
That's better spirit.
Try to keep them in the same order because we're going to show them to the jury here in a second. So do you recognize those?
I do.
Okay. So this visit, was it a few days or a few weeks after you got out of the hospital?
I believe it was a few weeks.
So, Judge, I would go ahead and move these in as collective exhibit 3 and ask permission to publish them.
All right, we'll pass those to the clerk and let her mark them as exhibit 3.
So I'm going to show you this first one and we're going to talk about it, okay? So who's this?
That's Raynell Jr.
Okay. So we're able to see here, you recognize that as your home. Is this his normal disposition?
Wait. He's like, you see how he's smiling and he's out. That's Junior. Yes.
Now, you didn't take these photos, so you don't have to apologize for the quality of them, but, okay, so we've got this next one. Are these photos that I'm gonna go through, is that Junior's injuries that day?
Yes, from being at my mother's house.
I'm gonna show you the third image. Are those your hands holding his in the pictures?
Yes.
That Junior's hand?
Yes.
And this last picture, is that Junior's hand there, the injuries that we see?
Yes.
Okay. And so I see both a cut towards the top and then a dark line towards the bottom. Is that right?
Yeah, and his fingertips was pretty messed up too.
Okay. Let me see. I don't know if it'll let me zoom in. Oh, it will. So you are describing those marks there on the tips? Okay. One second.
Yes.
That is all for the photographs. The house where where your mother lived, what was the address there, if you remember it?
3002 Slade Marion Road.
And is that here in Dixon County?
Yes.
Did you give your mother permission to tie your child up?
No. No, no.
Is the person that we've been talking about your mother, is she in the courtroom?
Yes.
Can you point to her?
She's over there.
Okay. Judge, if the record would reflect that he's identified the defendant.
All right, the record will so reflect.
Mr. Clinton, did you tie your child up?
No.
I have nothing further, Judge.
Mr. Belmars, you may cross-examine.
I want to go back. So you talk with General Bryson asked you generally about custody. So could you tell us what was the custody arrangement with you and Ms. Johnson in May of 2020?
In May of 2020, there was no custody agreement. I felt that her parenting wasn't up to, where it should be, and I was keeping it from her.
Okay, so at that time you were keeping the children away from their mother?
Yep.
Okay. And where were you living between May and October of 2020?
Man, October 23. I think I had my own house around there, in Clarksville on Providence Boulevard, over there.
And is that the one we saw in the pictures? That
Yes,
say-
on Oak Street, yes.
Okay. And so during that period, from May until October, the children, Mr. Junior Clinton and Mr. Jeremiah Clinton, were in Miss Kelly's custody.
I don't believe it was that long, but something like that. October, I started my job at a Gero, so they was not with her.
You started your job where?
At a Gero,
What is that?
roadside assistance.
Okay, a Gero Roadside Assistance.
Yes.
What date did you start that job?
I started there sometime in October, I believe it was the 6th of October or the 7th of October, 2020.
Okay, so you started on Outback Steakhouse on October 3rd, and then you started on a Gero on
I
October
was
6th.
at Outback before a Gero. I wasn't at Outback long, probably a month.
Okay, gotcha. Now, so you were taking classes 2 days a week, you said?
Yes.
All right. What type of classes were you taking?
It was to get my driver license reinstated. I believe it was cognitive thinking or something like that through Montgomery County probation.
Okay, so it was in Clarksville.
Yes.
All right. And you were doing that 2 times a week?
Yes, I believe so.
How many hours per class?
I'm not too sure. Maybe a couple hours, hour or two.
Okay, so you were in a class for maybe 2 to 4 hours a week, and during that period, you left the kids with Miss Kelly?
Correct.
Okay. And, um, and during that period, she would call you if anything of event happened that day.
Yeah.
And you seem frustrated that she shouldn't be calling you unless it was an emergency.
Not that's what I said. I said if it was how serious that she made it seem, why you didn't take her to the hospital. That was my frustration.
I think you said if it's serious enough for you to call me, why didn't you take him to the
That's
hospital?
what I said.
All right. And, I mean, it's your responsibility to take care of the kids, right? I mean, they're your kids.
Yeah, and it's hers too, her grandma, and they was out there with her.
Let's back up. So tell us about your home in Clarksville. What kind of home and what kind of location that was?
It was a mobile home.
Okay. Was it rural? I mean, was there a big yard, woods, anything
No.
like that?
No. Small front yard, but bigger than everybody else's because I was on the end lot.
Okay. Would the children play outside a lot
A little
when they were
bit.
at your house?
They had we had a neighbor they played with, friends they used to play with.
Now, so what about Miss Kelly's home? What kind of home is that? What is
She
it?
had a rural, I guess, in the country or something out here in Dixon County.
Okay, quite a few acres.
Something like that.
I mean, there's some big fields,
Yeah, something like that.
some fence lines.
Oh yeah.
Fire pits.
Oh yeah.
Things like that. Gardening.
Yeah.
Okay. And the day you picked the children up, Miss Kelly was out in the garden, right?
No, she was in the garage.
Okay, she was in the garage when
Yep.
you got there. Okay. So obviously she didn't see you coming or pulling up the
I
driveway.
guess not, because I walked up, she was in the garage.
Okay. And what date did you drop the children off with Miss Kelly?
I can't remember exactly what date. It's
was-
been 4 years, man.
All right, right, I understand. And what all did they take with them when you dropped them off with Miss Kelly?
I don't remember. I believe some clothes.
Okay.
But again, you mentioned her house. She had most of their stuff already over there. And my house, my mobile home was pretty small. I mean, it was a 3-bedroom, two bedroom, bathroom, but it didn't have enough room to store all their stuff there.
I got you. So there was a lot of stuff at Miss Kelly's house.
Yeah, there was still some stuff there.
And I mean, to be fair, you frequented the house quite a bit. Mm-hmm. And when you needed something, as far as helping take care of the kids or picking the kids up from somewhere, you'd call Miss Kelly and she'd come to Clarksville.
Right. Right.
She was in Clarksville quite a bit with Levi, right?
Yeah.
With his wrestling matches and things like that.
Well, wrestling was in Dixon. I don't
Okay.
recall him being in Clarksville wrestling.
Okay. Now, when you dropped the kids off, you said you showed up early. So when were you supposed to pick them up?
Well, I had, again, it was like a 10-week class, and I got done early. They let me go early. I don't know what made them feel that way, but they ended my class early. I got done, so I went out there to get them.
Okay, so when you dropped the kids off, the plan was they were going to stay with Miss Kelly for 12 weeks.
Or however long it was.
Well, for 12 weeks worth of classes.
However long the class was, yes.
Okay. And did you visit any time during
No,
those
I didn't
12
have a
weeks?
car. I mean, she came out there sometimes and with the boys and stuff, and
Okay, so she brought them to Clarksville to see
Mm-hmm.
you from time to time. Did you leave Miss Kelly with the medical insurance cards when you dropped them off?
I'm not too sure if I did or not.
Okay, did you leave her a power of attorney where she could take them to a doctor if she needed to?
I'm not sure if I did or not.
And back then, in May of 2020, I know it's been a long time ago, but that was COVID-19, right? I mean, the whole world was a different place.
Right.
And so so if you needed someone to watch the kids, why didn't they stay with Miss Johnson?
Ms. Johnson, because we wasn't seeing eye to eye. Again, I didn't like her parenting at the time.
And y'all, and I think y'all have already talked about, y'all had a bumpy relationship, you and Miss
Right.
Johnson. And I'll back up a little bit. Y'all had lived in Texas, and I don't want to get involved in all that of Texas, but y'all used to live in Texas.
Right.
And then when y'all came to Tennessee, were Jeremiah and Junior already born at that time?
Jeremiah was born, Junior was still in his mama's belly.
Gotcha. And when you came to Tennessee, you moved in with Miss Kelly,
Correct.
and she provided y'all a place to live.
Correct.
At that time, were you working?
No, I got hired at Subway not too long after being out there. That was my first job out here in Clarksville. And then we got a studio apartment, and then went from there.
I got you. And what about Mrs. Johnson when y'all first got to Tennessee? Was she working?
No,
She went to work sometime later, I guess?
later on.
Okay. And so when y'all first moved here, Miss Kelly was providing for you, for you and Miss Johnson, and
Yeah, she was helping us out.
your child and your other unborn child, right?
Correct.
Now, during the time that you lived with Miss Kelly, I mean, did she ever intervene in arguments between you and Miss Johnson?
Yeah.
And how many times would that have happened? Do you remember?
I know twice, or once or twice, but for sure, because Angelica thought she was finna go get a knife and come downstairs on me.
Okay. So she was after you with a knife and Miss Kelly intervened. And she would take up for, I guess, strike that. She would,
What is the relevance, Mr. This line of questioning, Mr. Belmar?
well, Your Honor, I mean, the relevance is Miss Kelly is the constant involved in these children's lives through years of providing stability, trying to stop violent situations, trying to keep everyone calm down. That's the relevance.
I don't, the relevance definition is whether some piece of evidence makes the allegations against the defendant either more true or less true, and I don't see how this is relevant. Sustain the state's objection.
I want to talk specifically about July 16th of 2024. On that date, Miss Kelly sent you a picture of the clock that was broken, correct?
I don't remember.
Now, you told the state you hadn't gotten any pictures, so you had not gotten any pictures, or you did get pictures?
I don't remember.
You don't
I
remember?
think she did send me a clock though.
Okay. She had to send you the clock because you showed it to the staff at Vanderbilt Hospital.
Okay. Yeah.
Correct?
Yeah, I think so. Yeah.
Okay. And I guess you said a China clock. What's a China clock?
I don't know, old school clock, my wood clock with glass,
Okay.
right?
So it's not like a clock on the wall, it's one that stands up.
No, one that stands up like in your grandma's house.
Okay. All right. And she sent you that picture on July the 16th, right?
I guess so.
And also on that date, she video called you and showed you that as well, correct?
I don't believe so, but I think so, maybe.
And during that video call, were the children all in the video?
I don't recall.
Okay. And you don't remember if Mr. Jeremiah Clinton was still asleep at that point?
I don't recall. I don't.
Did she send you more pictures later in the day of Junior being in timeout on the front porch?
Not too sure.
And when you were on the video, there weren't any injuries to Junior at that time, were there?
I don't remember seeing Junior in the video.
There wasn't any blood in the picture?
I don't remember seeing a video of them.
Now, before you showed up to pick up the children at Miss Kelly's house, what was the last time you had spoke to her prior to that?
I do not remember. Maybe it was when she came over and we got in an argument. She called me stupid, and I told her I was fucking stupid.
Okay. When was that?
Sometime before all this happened with Junior and his arm, his hands.
Okay.
So maybe that was the reason.
So was that a week before you picked the children up? 2 weeks before you picked the children up? When was that?
Could be.
Okay, you don't know if it was a week before or 2 weeks before? You don't know any details whatsoever?
I mean, it's fuzzy. It's been 4 years. I've been going through so much, doing so much. I got so much on my mind, like.
Refresh my memory.
Now, what time of the day did you arrive to pick the children up at Miss Kelly's?
I think that was like afternoon, like maybe around after 3 or closer to 3 or 4 or something, maybe.
You've already testified you didn't go to the park that afternoon, you went the next day.
Yeah, I believe we went the next day.
When did you go to Chuck E. Cheese?
I didn't take him to Chuck E. Cheese.
Okay.
I took them to Chuck E. Cheese when I got them back from Angelica, when she was keeping them away from me. That's when I took them to Chuck E. Cheese. Oh, I took the kids to Chuck E. Cheese when I got them back from Angelica, when she was keeping them away from me, not when I got them back from my mama.
Okay. When was that? Was that before or after this?
That was after this.
Okay. How long later do you think?
Maybe 2022-ish.
Okay.
20, maybe.
So when you got there, you said Miss Kelly was in the garage. Where were the children?
I think Junior was in the garage too. I don't remember where Jeremiah was. I just remember Junior and seeing his hands, and from there it's like, I believe we was talking about his head and how he tripped and fell on the stairs or something, and I thought somebody pushed him over because I don't know. It was no.
Now, when he tripped and fell up the stairs, you said that Miss Kelly called you at that time, correct?
Correct. I think she did.
And did y'all have discussions about concerns that he may have some sort of diabetes or some sort of issue?
No, but Junior he didn't have any medical problems.
And so whenever you got there, how long did it take the kids to pack up everything before they left?
Not long. We was gone. After she was, I guess, putting bandage on him, we took off after that.
And
We might not even have much stuff because all the stuff was already at her house that she needed.
right, right. And did Miss Kelly? You said she was put bandages on Junior before he left.
Yeah, I think she tried to change the bandage because when she pulled the first one off, it was bleeding. She said she needed to change it or something like that.
And she cautioned you that it needed to be changed.
I was right
Correct.
there with her in the house.
And did she pack up? She packed up some supplies for you to take with you when you left, correct? As far as gauze, Neosporin, things like that.
I don't know. I think she did.
When's Jeremiah's birthday?
7/26/14.
Now, what day did you pick them up? Do you remember how many days it was before you took them to the doctor excuse me. Do you remember how many days after you picked them up before you took them to the doctor?
I didn't take him to the doctor until like a day or two after.
The medical record said that you picked them up on Tuesday the 4th and took them to the doctor on Friday the 7th. Would that be accurate, you feel like?
Could be. It was a few day or so.
And who all was in your house between August the 4th and August the 7th?
It was just me. Pretty much just me. I live by myself. Unless I have my kids there, I was by myself. And I have company come over every now and then.
Now, once you decided to seek medical attention, you took them to an urgent care clinic in Clarksville, correct?
I took them to their pediatrician.
Well, so you certain that you didn't first take them to an urgent care clinic where they couldn't verify their insurance and then took them to their pediatrician?
I'm sorry, say that again?
Are you certain you didn't first take them to an urgent care clinic and then take them to their pediatrician after the urgent care clinic couldn't find their insurance?
I'm not too sure. I'm probably, maybe, but I know for a fact that I took him to the pediatrician, and then we went to the hospital.
And they were established patients with a Keno pediatric.
Yes,
And you had been the one taking care of that.
yes.
I mean, you're pretty religious about going every 6 months to their checkups,
Oh yeah, they go to their checkup, they go to their dental. Oh yeah,
taking their shots.
take their shots, all that. I got all that done.
Yep, and you were the one that did it.
Yep, I got help from my mama.
Right, but Ms. Johnson wasn't involved. You were doing it. At
No,
that.
I got it done.
Yes, sir.
I got all that done. The junior circumcision, he had to get circumcised later as a little bit older because the mother didn't felt to do it when he was younger. So I took it upon myself to get all of it, everything that needed to be done. I did it myself. So yeah, I kept them from her, but it was for a reason.
You followed up with all that. I mean, but you had a history of taking care of that stuff, all the medical stuff. Followed up about the circumcision. You took him to Vanderbilt for that.
Yep.
Followed up with all the follow-up care.
Yep.
Took him to the pediatrician every 6 months. All that.
Yep.
No problems at all.
Nope.
Now, when you were there at Aquino Pediatrics, you had already asked Junior what had happened, and he told you he didn't know, correct?
I think so. Yeah.
And then when you're at the doctor, again, he said he didn't know, correct?
I think so.
And the Clarksville police responded to the doctor's office.
Right.
But they didn't interview him, did they?
I'm not sure. I think they talked to me for a little bit. I don't know if they did talk to Junior or not, but they pulled me out and talked to me though.
And then from there, you actually went to the hospital in Clarksville, right?
Yeah, Keno took us across the street to the hospital in Clarksville, and we waited on the ambulance to take us to Vanderbilt.
Okay. And then they took quite a while to get all that done as far as getting the transfer done, didn't it?
Kind of not. We were waiting a little bit at Clarksville, but after that, it was it ended up happening pretty quick, I guess.
And during that period of time, did you call Miss Kelly and ask her to come pick you and the child up and take him to Nashville, to Vanderbilt?
No.
When you got to Vanderbilt, I mean, the first thing you do when you get there, you have to give a history of the present illness of the child, correct?
I don't know.
And you go in and they ask you what's going on while you're there at the hospital, right?
Yeah.
And you reported to Vanderbilt that you thought it was a rope burn or a heat burn to the child's wrist.
Correct. That's what it looked like to me.
You're also concerned that that someone might have done something to him sexually as well, correct? Initially.
I didn't know they checked him for everything. Regardless of what I felt, they checked him for everything to make sure nothing did happen to him.
And you told the doctors at Vanderbilt that Junior was his right hand was bleeding profusely when you got him home that night. So when you picked him up from Miss Kelly's that night, it was bleeding profusely. What part of his right hand was bleeding?
The scar that's on his outer hand.
The top of his hand here?
Yeah.
So not up here around his wrist, but on his hand.
The wrist was bleeding bad too, but his hand was where it was gushing.
You reported that you'd been treating with Neosporin and you'd been wrapping it up as necessary and things like that, correct?
Yeah, put him in the bath, give him a lukewarm bath, soaked it,
soap and water, Neosporin, peroxide, whatever I could health-wise.
So you were soaking his hand, put him in the bathtub, put peroxide on it, Neosporin, and wrap it up. Now, you also reported to Vanderbilt that you thought that Junior's arm was broken. When did you decide that?
I don't remember saying his arm was broken. I don't remember saying that.
Then after you left Vanderbilt, or after you were discharged, and you said you were there, how many days you believed?
Somewhere like, I think like 3 days.
Would it surprise you to know that you were there right at, or maybe even less than 24 hours?
No, it felt long. It just felt longer.
Now, after that, you had some discharge instructions, and you'd been told to follow up with Byrne.
Right.
After that, correct?
Right.
And then you had some contact with DCS,
Correct.
Mr. Hicks and Miss Doherty.
You said Miss Hicks?
Mr. Hicks and
Mr.
Miss
Hicks.
Doherty?
I don't remember the guy. I know a lady came by the house though. A lady came by the house.
So the first visit was from a male DCS or
At the house
investigator,
or
correct?
at the hospital?
At the house.
I don't remember.
You don't remember that interview of the children,
I remember a lady came to the house a few times, but not a guy.
but you don't remember the gentleman.
I don't remember the gentleman.
Do you remember calling him after and telling him that Jeremiah had told you that Junior had been tied up?
I think so. I remember Jeremiah telling me that though.
But you don't remember calling DCS and telling him that?
I probably did.
Okay. And Jeremiah was the first one to say anything like that?
I think so. Yeah, I think Jeremiah was the first one to say what actually happened.
And so tell us, how did that conversation occur when Jeremiah made that disclosure? Were you asking him questions, or did he just walk up and tell you that? How did that happen?
I don't know. I think I was asking him questions. What happened?
Okay. And then Miss Doherty, the lady DCS worker, she came at some point and took you to a forensic interview, correct?
I think so.
Um,
I don't know, man.
you don't know if she did or not?
I think I had a forensic interview.
And when y'all got into the vehicle, Jeremiah made a spontaneous statement. Are we going to go talk to the lady that is going to put Granny in jail for hurting Junior? You remember that?
I don't remember.
What type of discipline did you use with the children?
I spanked him.
Spanked them. And did you spank them with a belt?
Oh yeah, I spanked their ass with a belt.
And did Miss Kelly caution you about that and talk to you about not doing that?
Not that I remember.
I mean, was it such that Junior was afraid of belts? So like when he saw a belt, he would react?
I think they both did because they know when I got my belt, I was dead serious about what I was saying. And they need to get their attitudes correct.
Right.
Right.
And so, I mean, you had done that enough so that you wouldn't have to even whip them with a belt. If you took your belt off, they knew that they
They
better
know
straighten up.
that I meant business and get it in line.
Now, when the children got, or excuse me, when Junior got discharged from Vanderbilt, he, we talked about he was supposed to follow up with Byrne. After that, you didn't take him to that appointment, did you?
To which one?
To the Byrne follow-up on August the 17th, 2020.
I think I did. If I didn't, I didn't have a ride.
Okay. But you did take him to Keno Pediatrics not long after that.
Yeah, I
Right.
would think I was making my keynote pediatric. I think I took them because I was using the Mid Cumberland transportation services when I had appointments. So I think I did take him to his appointments.
If you told Keno Pediatrics that you didn't take him, and that's in the records, that would be reliable, wouldn't it? I mean, they would
Yeah,
know
it should be
was-
in the records that I took him.
And you were referred to, he was referred to physical therapy and occupational therapy in neurology, correct?
Right, he did that. I think I got him started with that, and then Angelica finished it out and was to start taking them.
Okay. So you believe you started with those things and Angelica?
Yeah, I think I
finished
got the
them out.
initial appointment with the physical therapy started, and then after that, they was with her, and she started taking them.
And so how did it become that the children went from living with you to Miss Kelly, then back to you, and then living with Miss Johnson?
Because it was a conversation between me and the kids. They really wanted their mother after that traumatic experience, and regardless of how I felt, I made that call to their mother.
Did Miss Humphreys, did she interview at any time during this case?
I don't remember her. I was talking to some lady though, and then I don't know. I got pressure from my family, so I was just like, just let it go, whatever. But here we are today.
I have just a moment, Your Honor.
You may. Redirect.
You said you were getting pressure from your family. What do
Right.
you mean?
Tell me not to do it and whatever.
You're still gonna have to be more clear than that. Who was telling you not to do what?
Her sister, my aunts wondering if I'm gonna testify or press charges or whatever the case is against her.
Your
My mother,
your family members
Yes.
did not want you to participate in the prosecution of your mother.
correct.
Nothing further.
Recross. Thank you, sir. You may stand down.
Can I leave or do I gotta stay here?
You can leave if you'd want,
All
unless the
right,
state
thank y'all.
wants you to stick around. So. Counsel, approach the bench. It takes a couple of hours. Ladies and gentlemen, we have one witness that the state has subpoenaed that we're trying to determine whether or not we can put her on this afternoon. It's the pediatrician that's involved, and it may be a very lengthy examination, both direct and cross-examination, so I'm trying to get a handle on that. Has anybody got anything going on tonight that you need to get home in a hurry, other than just tired and would like to get home? If we don't do it tonight, we'll have to come back, and I'm just tomorrow morning, so we will be coming back tomorrow morning because the case certainly will not finish. Yes, sir. I'm sorry. Oh, the photographs that you had that were being passed around, you didn't get to see. Well, yeah, pass them around. Go ahead and give them back to him. I forgot we had taken them away from you when you went on break. Thank you for bringing that to our attention. I don't think they saw all of them saw the first set, so just pass them all. Call your next witness. I have instructed that the jury could view those photographs that you were made an exhibit. They were not able to finish viewing them before we took a break while ago. So. Ladies and gentlemen, we're going to keep going to try to get this pediatrician taken care of today because she has patients to see tomorrow. If anyone needs a break, at any point, please just get a hold of one of our bailiffs or flag me down and we'll take a break, even if it's just to stand up and kind of wake up. So. You'll come up, please, ma'am. Mr. Clerk.
I do.
Thank you. If you'll have a seat there, please.
Judge, the state and the defense have stipulated that Dr. Aquino, as the supervising physician, may testify from the treatment records.
All right. The stipulation, ladies and gentlemen, means that both sides are agreeing that certain facts are true or that certain documents can be used. In this case, they're stipulating that this doctor can testify directly from her notes and the medical records.
Okay. Are you Dr. Barbara Aquino?
Yes, I am.
And would you spell your last name, please?
Aquino.
Okay. Now, Dr. Aquino, where did you work in 2020?
I own my own practice, Aquino Pediatrics, and I've been in practice since 1996. So in 2020, I was a practicing physician and also a supervising physician until I retired just last year, December 2023.
What education and training did you have to receive to become a pediatrician?
I have you have to have a 4 years medical degree, and then you have 3 years actually of what do you call residency, and then after that you take your boards. So it's practically is about 8 years post.
Did you have a 4-year pre-med degree?
Yes, I did.
Where was that from?
4 years, that was in the Philippines, and the name of the medical school is University of Santo Tomas.
Okay. Could you spell that for our court reporter? Because I don't know that she's going to get that. The university name?
University of Santo Tomas is spelled as Santotomas.
Okay. And were you a board, you said you had to take your boards, so were you a board licensed?
Yes, I
pediatrician?
am board certified.
That's the word I'm looking for, board certified. Okay. And is that a certification that you maintain throughout your career?
Yes, I maintain my certification.
Judge, at this point, I would ask her to be qualified as an expert in pediatric medicine.
Any objection?
Yes.
All right, this witness will be qualified as an expert in the field of pediatric medicine. Ladies and gentlemen, and the final instructions I give you will be some additional instructions about expert witnesses, but just for this moment, at least just be advised she is qualified as an expert in this area.
Dr. Aquino, did you actually see Raynell Clinton Jr.?
No, I did not.
Okay. He was seen by a nurse practitioner in your office?
Yes.
Okay. Could you explain to the jury the relationship between a supervising physician and a nurse practitioner?
Nurse practitioners are licensed and qualified based on their completing their nurse practitioner degree and also taking their license in nurse practitioning examination.
And then what's your relationship to them as a supervisor?
I am supervising them 100%. So I am there since I am the owner. I am there in my office practically the whole 8 hours or so. So I am there if they need any questions. I am also practicing. So I'm also seeing patients of my own during the 8 hours that the office is open.
Can a nurse practitioner practice outside of the supervision of a doctor?
No, they cannot. Under the present Tennessee law or so, they cannot. They have to be working under licensed pediatrician.
So do you review your nurse practitioner's work?
Yes, I can honestly say that I reviewed their notes 100% before signing them.
So before we talk about this case specifically and what the nurse practitioner did, I'd like to ask you some general questions about what your reaction as the pediatrician would be to certain injuries coming in on a child under the age of 4. Okay. If you have a child that's coming in under the age of 4 and there are marks that go all the way around the child's wrist, what is your immediate reaction as a physician?
First of all, I have to say the patient is 3 years old, so I have to look at the developmental milestones of 3 years old. And at 3 years of age, to have ligation marks on the wrist, it's impossible for a 3-year-old to do that.
What do you mean? Explain to me.
At 3 years old, for somebody to tie a ribbon, maybe you can do it as early as 4.5 to 5 years old, and to be able to tie a shoelace, then probably about 5 to 7 years old, you can do that.
Okay. What about to tie something on your own wrist?
So tying tying your own wrist at 3 years old, and the fact that the circumferential ligation marks is there, it's impossible for a 3 years old to do that.
Okay. So, in this case, what if any findings, what if any observations were concerning to the nurse practitioner that saw Raynell Clinton Jr.?
Can you explain that again, please?
Okay. Let's, well, actually, let me back up and start a little bit earlier. Was the child in this case seen before the abuse concern? Had he been treated in your office before the day he came in with injuries?
Did I what?
Did he normally have his well visits at your clinic?
He usually has a well visit. We first saw him in the clinic on May 13, 2018, and he came in for his 19 months well checkup, and he kept his regular periodic visits. We see him also on his 2 years well checkup, and also 2.5 years well checkup, until he came in on 8/7/2020 for his 3 years well checkup, and that's where the event that we're talking about right now.
Okay. Were there any concerns of abuse before August of 2020?
No.
Were there any concerns of abuse on August the 7th, 2020?
What did you say again?
Were there any concerns of abuse on August the 7th of 2020?
Yes, in fact, the dad made an appointment for a well checkup, but then when Lauren, the nurse practitioner, saw the patient, she was alarmed. She said, "No, this is not a well visit. This is a possible abuse case." So
Okay.
we considered it as such.
What is indicated in the records that she observed about the child indicating abuse?
The patient was observed by the nurse practitioner that he had hand injuries. He had lots of bruises, scars, and burns. Dad was very concerned as the patient was acting nervous about his private parts.
Okay.
Patient was very subdued also.
Right. In the notes previously, how does the doctor describe the child's attitude? Is he ever described as subdued before this date?
No, this is the first time. In all the visits, the patient has always been very active and very playful. But on this visit, the patient was very, as described, as very subdued.
Okay. In the medical records on that date, does it indicate that Dad called his mother in front of the treatment provider?
I'm not sure, but I think it's on the record. Yes, the dad called his mom and asked what happened, and the mom was angry at the dad and said that, "I don't know, he must have fallen off the stairs."
I'm going to direct you to the visit on 8/7/2020, where we have a history of present illness and new symptoms. The paragraph starts with Raynell's dad does not recall, but I'm going to direct you down to where it says that Raynell's father called his mother while in the office and asked you what the records indicate about the mother. And I'm sorry, I should have waited till you found that page when I gave you all that information. So this is the visit from 8/7/2020.
It says here that on the notes, Raynell's dad does not recall any history of abuse as a young when he was younger. His mother is not sure what happened, but denies that he cannot be burned. Reynolds' father called his mother while in the office on speakerphone. His mother yelled that she did not know what happened, but he wasn't burned and hung up the phone.
So let's skip down and talk about the specific, and let me be clear, he was, what date was he treated? I think I already said it, but what date was he treated for observed for the injuries?
He was seen on 8/7/2020, and because of his injuries, the nurse practitioner thought that he needs to be evaluated by a tertiary facility, and we referred him to Vanderbilt ER. And Vanderbilt emergency room physician recommend that we transport him via ambulance. So we called EMS, and we also called the police department.
Is that your normal protocol when you as a pediatrician suspect non-accidental injuries?
Yes, we do that.
What injuries are noted to the skin in that visit?
I read my notes again, as I did not see the patient. On his skin, there are linear, hyperpigmented, circumferential marks on both wrists.
Okay, so let me pause and let's break those down. Linear, so that means in a line, right?
Pardon?
Linear means,
That means to say it's linear, very smooth, circumferential marks on both wrists.
okay. And what does hyperpigmented mean?
It's a healing process. Most people heal by darkening of the skin, and some people heal by whitening of the skin.
Okay, so linear hyperpigmentation, lines around both wrists. What next?
There's also either partial thickness burns versus abrasions noted on the left wrist, also noted on the hand, and also on the right palm.
Okay. What does that mean, burn versus abrasion?
It's so hard. We don't want to make presumptive diagnosis. So there is an erosion on the wrist. So we call it it was an abrasion through whatever method. So we just call it abrasion versus burns.
Okay. And what is the word? I know we're breaking this down into its simplest version. What does abrasion mean?
Abrasion is just more of an erosion, any break of the skin.
Okay. What else? What, if anything else, was observed? What else was observed?
There's also erythematous or red, and there's also black spots noted under all of the left hand fingernails. And there's also on the fingertips. So it's either red or black marks on all the left fingernails and the tip of the fingernails.
Okay. I'd like to direct your attention on that page down to the treatment. Was there concern of a broken bone?
There's always a concern for a broken bone. So when he was seen at Vanderbilt, they had to do a full skeletal survey on him.
Was your treatment provider afraid that there was a broken bone?
Yes.
What in what she observed raised that concern? Why did she think there might be a broken bone?
Well, there are multiple bruises all over the body in various stages of healing. There's also a large contusion or a bruise on the left lower back, so the lower back. There's also a laceration on the left eyebrow. There are also multiple lacerations and scars to the upper back. He has an abdomen that is distended. He also has a knotted deformity on the left forehand, and he cannot rotate his left arm. And his left arm and left wrist look swollen. He has a poor strength on the left upper extremity, and he has a poor eye contact.
As part of a normal physical exam of a child this age, do you normally examine their genitals?
Yes.
And what, if anything, was concerning in his exam?
Pardon?
Did the child let someone examine his genitals that day?
At this visit, he was very afraid of a possible private examination.
Was he seen a few weeks later as a follow-up?
Yes,
Okay, what date was he seen a few weeks
he
later?
was seen in our office on 8/31/2020, so about 3 weeks after he was admitted and discharged from Vanderbilt.
Were injuries still visible that day?
The injuries were still observed, but it was showing some healing.
Is there any indication in the records if the child would use his hand at that point?
Of what?
Do the records say if the child would use his hand at that visit?
Yes, on that visit, a patient has limited, there's a poor strength on the left upper extremity. He has limited range of motion of the left wrist and the left hand. And there is generalized tenderness, so it's tender to touch it. And he will not squeeze the hand of the examiner. And he does not use his hands at all. The capillary refill of his left fingers are slower than the right.
Okay,
And
now I think I
also-
know what that means, but hold on. What's a capillary refill?
That means to say it's a good circulation, that's a test of a good circulation. So if you press your thumb or any kind of a finger, then you count how soon does it from pale to red again. And it's usually 2 to 3 seconds is normal. But at that time, when they test his capillary refill on the left fingertip, then it's slower refill than compared to the right. And also, the hands feel cooler than compared to the right.
What is the significance of those two things?
Significance is there a compromised circulation on the hand that is in question?
Okay. Were there any referrals made that day?
A referral, it was already called to Vanderbilt emergency room, and he was already transported by ambulance, by EMS, and that's where all the workup were done.
Okay. Was there another referral to physical therapy, or am I misreading this?
There was also a referral because he cannot move his left hands, so a referral to physical therapy was also done, but that was at a later visit.
Okay. Now let's skip forward a year to August the 16th of 2021. Was he seen in your clinic again?
On August 16, 2021, the patient was brought in by dad for his 4 years well checkup.
Okay. And what's the update on his arms at that point?
The patient was observed to be very talkative, very active, and he has a full range of motion of all his extremities. The motor strength is normal for the upper and lower extremities. And at that time, there was no abnormal findings noted by the nurse practitioner. Now he has an equal strength, equal pulses, and the capillary refill and movement of his left upper extremity is back to normal. The nurse practitioner was impressed how well the left wrist and hand healed, and there does not appear to have any lingering injury.
In your practice, if you had concerns regarding dad, would you have noted that in the reports?
Yes.
Are there any notes in these files that the practitioner was concerned about dad's behavior?
No.
One moment.
nothing further for this witness at this time, Judge.
Mr. Bell Myers, you may cross-examine.
Good evening, Dr. Aquino.
Good afternoon.
I think we spoke briefly out in the hallway, but that's the first time we've ever spoken, right?
Yes.
So, Dr. Aquino, could you tell us a little bit about, I guess, the flow when someone comes in your office, who makes initial contact, who obtains history, things like that?
I'm sorry, but can you talk a little bit louder?
Yes, ma'am. Yes,
I have a hard time hearing. I'm sorry.
Could you tell us who makes initial contact when a patient comes in the office, who obtains the history regarding the present illness, and things of that nature? Just a little bit about the flow through the office of how that works.
I'm sorry, I still can't get it. I have a hard time hearing. And you have a soft voice.
Yes, ma'am. Could you tell us a little bit about the workflow, like when someone comes in the office, who makes initial contact, who obtains the history, and things of that nature?
Usually in our office, we have separate appointments for nurse practitioners and we have separate appointments for the pediatrician. And at any point, the nurse practitioners can always interrupt me to see the patient for second opinion or for treatment or anything.
And I guess one thing I noted when I reviewed your reports, part of what your office does at every well visit, you give kind of an education component, correct? You give like an education component. There's things that you tell the parents to be aware of like keeping the home safe and making it childproof and things about diet and just general welfare things. Y'all give an education about that?
I am sorry, I'm getting embarrassed in here because I have a hard time hearing and his voice is a little bit soft, so I keep asking, can you repeat the question? I'm so sorry, but I have a hard time understanding you and I don't want to make any comment, otherwise it will not be fair for anybody.
Yes, ma'am. Yes, ma'am. Part of your well visits that your office does, there's an education component with the parents during those visits, correct?
There's education to the parents?
Yes, ma'am.
Yes,
And some of those things you talk about are how to childproof a home. You talk about diet, just general things,
yes, we
correct?
do.
To try to, as kind of preventative medicine, right? To try to minimize accidents and things like that.
Yes, preventive medicine, prevent accidents.
And Mr. Raynell Clinton Jr., he was an established patient, correct?
What is it?
He was an established patient. He came to your office regularly.
Yeah,
And he was always with his father when he came in, correct?
he is.
And so I want to back up one visit. On July 2nd, 2019, could you tell me what atopic dermatitis is?
July 2nd, 2019, atopic dermatitis is just a very exotic term for eczema, dry skin.
Okay, okay. So that, other than circumcision, was really the only medical diagnosis that Mr.
That's the
Clinton had ever
diagnosis,
had.
yeah.
Now, on 8/7/2020, when the child came into the office, do you know at that point what treatment had been attempted on the child?
There was no treatment rendered, but a referral was made. So if that is considered a treatment, a referral, an urgent referral was made to Vanderbilt Emergency Room for further evaluation, and that's what needs to be done.
And I guess what I'm asking is, do you know if dad had treated the child at home before that?
What did you say?
Do you know if dad had attempted to treat the child before that?
Do I know the dad?
Do you know if Mr. Clinton, the father, had attempted to treat the child before they presented in your office?
No.
Okay. And do you know if Miss Patricia Kelly attempted to treat the child prior to their coming to your office? You don't know if Miss Kelly had tried to treat the child either, correct? There's no way for you to know if they had tried to treat the child before they came to your office.
No, no.
Do you obtain patient history from a child under 4 years of age?
Yes.
Okay. And what type of information are they usually able to give you regarding patient history?
Can I read it on language communication?
Yes, ma'am.
Can I read it? The milestones of a 3 years old, they can talk with you in conversation using at least 2 back and forth exchanges. They can ask who, what, where is your mommy, where's your daddy? So that's a typical 3 years old. They can say what action is happening, like, okay, he is running, he is playing, he is eating. He can say his first name when asked, and he can talk well enough for others to understand.
And when Mr. Clinton was asked what happened, he told your office repeatedly he didn't know.
He did not
Correct?
know.
And who developed the theory that it was a burn? Did Mr. Raynell Clinton Sr., the father, first state that theory, or was it your office, your staff that stated that theory?
What did you say about the dad?
Who first decided that it was a burn, or first discussed the theory that it might be a burn?
What makes us suspect that there may be a bone problems?
A burn. Did Mr. Clinton suggest that it was a burn, a rope burn or a friction burn to the child, or did your staff suggest that?
No.
Who suggested that?
It's based on the observation of the nurse practitioner.
Now, you say circumferential marks.
Yes.
Okay. Can you tell me exactly what circumferential means?
Circumferential is around, circular,
Okay. And so would that mean all the way around the hand?
all the way around both wrists.
Okay, like your watch.
Yes.
Not like around the outside or around the
No,
all
it's
the way.
circumferential, so that was described as uniforms, like marks around both wrists.
Okay. And he had one on each wrist.
It doesn't have, no, it's on both wrists.
Correct. Okay. Now, there are other burn versus abrasions on the hands,
Yes.
correct?
Yes.
So those particular wounds, we don't know if that is a burn or an abrasion.
Yes.
And you said that that doctors are very careful not to
Yes,
make a diagnosis
yes,
when
yes.
you can't tell for sure. So we really don't know what caused those particular injuries.
No, we don't know.
Okay. Now, so Mr. Junior Clinton was referred to Vanderbilt, and they kept you informed of what was going on during that treatment to some extent, correct?
What is it?
Vanderbilt would keep you informed as the primary care provider what was going on to some extent.
They send admission history and they send a discharge summary.
They sent a CT report that said there was no findings in the CT.
They did a CT scan.
Yes, ma'am.
They did a CT scan on the head and it was a normal CT scan. That means to say no hemorrhage, no injuries in the brain.
They also did an X-ray survey, so I guess that's everything, right?
They did also a skeletal survey, which involves everything from head to toe, and they could not find any kind of a broken bone, either acute or remote. So that means either acute new fracture or an old broken bone.
And they also did some testing regarding blood and blood clotting to check for internal injuries.
You may. It's on the record. Cross-examination, you'll be allowed to proceed.
And I'm saying that very, very, I guess, elementary, or how I understand it, but there were tests done to make sure there were no internal injuries, correct?
I have a stare blank again because I can't understand your
Yes, ma'am.
question.
Yes, ma'am. We'll stick to those two tests. So initially, there was some concern regarding the need for a head CT and X-rays based on initial observations. But later, after testing, it was determined that those were not concerns anymore, correct?
Which is good. There is no major injury on the patient, which is a relief, but there are injuries, there are other superficial injuries.
And that's generally how medicine works. You take the information you have, you make a hypothesis, and then you test it, correct? Okay. Now, when Mr. Clinton was discharged from Vanderbilt, he had been given instructions to follow up with Byrne following that, correct?
To follow with,
With Byrne at Vanderbilt?
yes. And I didn't think they showed up.
Yep, and so then on 8/31, when they came to your office, the father stated that he did not follow up with Byrne because he was more concerned about the patient not using his left hand. And it was recommended that he follow up with Byrne, especially since there was a DCS case, correct?
Yes, that was the recommendation. That was what the father told the nurse practitioner, that they didn't follow up the burn center.
And so at that visit, you referred, or your office referred him to physical therapy and neurology. And you received reports from neurology and physical therapy, correct?
Yes.
So I have a fax that's dated 11/5/2020 from Advanced Therapy Solutions. And I'm going to point you to page 5 of 5 of that fax. You have it?
Yes.
Okay. And during the family caregiver education, it's noted that they asked mom to encourage as much active movement of the left hand as possible, correct?
Yes.
So at that point, the mother was handling the medical care with physical therapy.
Yes, at that time, the mother was brought by mother to that visit,
Okay.
and
And that was,
physical therapy was ongoing.
and that was the initial physical therapy visit, wasn't it?
The initial therapy evaluation took place on October 4, 2020,
Okay.
and his visit to Vanderbilt was December 9, 2020.
Okay. And both of those were by the mother.
What-
Both of those, he was taken by his mother to those follow-ups. And ultimately, he completed neuro, and I think you've already testified to where his hand, he regained all use of his hand. There weren't any more problems with it. May I have just a moment, Your Honor?
You may. Redirect.
Dr. Aquino, I'm going to look at two separate records that the defense talked to you about. One is from the date of the injury treatment. So that's the August the 7th, 2020 record, okay? And I'm going to direct you to the second page of that, down where he was asking you what the child said about his injury.
Are you talking about our records in our
Your
office?
records.
Our records in the
Yes,
office?
okay. So you recorded, or Miss Nurse Practitioner Carter recorded, Raynell stated multiple times he doesn't know how he got hurt.
Yes, it was Lauren that saw the patient on that day, not Miss Carter.
Excuse me, Lauren Bristol, Nurse Practitioner Bristol recorded that Raynell stated multiple times he doesn't know how he got hurt.
That's correct.
Okay. So what we don't see from looking at this record, we don't know how that question was asked, do we? And I guess what I mean by that is when doctors or the nurses are taking down information, they're taking down responses, not all of the questions that they asked, right?
Yes.
Okay. Now, I'd like to turn your attention, Mr. Belmaris talked to you some about the faxes that your office received from Advanced Therapy Solutions.
Okay.
Can you find the one from November the 5th?
That was the physical therapy initial evaluation.
Yes.
Okay.
So this would be 3 months after the August visit in your office. What do they record to be Junior's limitations?
He was assessed to have very limited use and strength of his left wrist and hand. He also does not report any pain on passive or active range of motion, though. He does not complain of any pain when you're gripping or grasping, but he does wince in pain when you press on his arm or wrist. He was also noted to have significant weakness of his left hand compared to the right hand. And he has a difficult time squeezing the therapist's 2 fingers. And he maintains a very light grip on a cylindrical toy that was given to him.
And what other activities did they do with him that day to see how he would use his hand? And I'm looking at a fax from November the 5th, but I'm wondering if it may be if the records are actually from October. I'm looking at a physical therapy care plan,
Yes.
okay, where they talk about his current level of function.
Okay, care plan, current level of function. Can I read the current level?
You may.
It's a little bit on the longer side, and it's okay.
Yes, ma'am.
Junior can assume quadruple position. However, the weight appears to be primarily placed through the heel of the left hand.
Okay.
He will extend his wrist at times to prop himself through the left upper extremity. He can climb a small ladder to descend a slide independently, but does not grasp the ladder with the left hand and rather use the forearm to push through. He is unable to isolate each finger in order to count 1, 2, 3, 4, 5. And he presents with limited wrist deviation.
What does that mean?
That means to say he cannot rotate it right or left or up and down, so he has a very limited range of motion.
What else?
He can trip a ball using the right hand and the left forearm. He can throw overhand with the right upper arm.
That's sufficient. Okay. That's enough on that one.
Okay, okay.
So all of those indicating in November that he was not fully back to using
That's
his
correct.
hand. Okay. Nothing further, Judge.
Recalls?
But when he followed up in your office in 2021, all that was healed up. He was in good shape as far
That's
as using his
correct.
hand. Thank you.
Anything further for this witness? Thank you, Dr. Aquino. We are releasing you from further testimony, and you may be on your business. Enjoy your retirement. So,
Okay, thank you.
Thank you. All right, ladies and gentlemen, we're going to stop for the day and resume tomorrow morning. One of the cases that I told you I was having to juggle It was going to take longer than I thought, and I told him to be here at 8 o'clock in the morning. So we may be in court holding a hearing at 8 o'clock on a different case before, when you come in. So if you'll just come in and, do you have them assembled in the jury assembly room? Yeah, just come in there, and then Officer Howell or one of the others will direct you back up here. But I'll try to still finish that one before 9 o'clock so we can get started on time. So we are adjourned for the day. Oh, ladies and gentlemen, let me remind you of my instructions in that initial instructions about not discussing the case, and don't try to do any research, and don't try to look anything up about this case, okay? I appreciate it. Thank you.
Being loud, because I can see you.